All right, well, good evening, everyone. My name is Michelle. I'm with the Meridian Library. I'd like to welcome you to Files for Life this evening with Mark Wight from Idaho Estate Planning. Everybody has been muted. The cameras are off. We are recording this session. If during the course of the evening you have questions, please use the chat box to type the questions. They can either go to everybody or to me, and I will interject for Mark as he's progressing along in case there are any questions. So with that, go ahead and get started, Mark.
Very good. I hope everybody can see the slide that says Files for Life, because if you can't see that one, you won't see any of the others. So if that's an issue, let us know right away. It's good to be with you. Those of you that have joined us for the other ones, thank you for coming back. Those of you that didn't join us for the other ones, oh, did you really miss something? No, thank you for joining us tonight. And in fact, you can, Michelle, do we have those up on the library's web page, the other two?
They are not live on the web page yet. We will get there.
Okay, so you'll have a chance to see those and catch up on some of the basics. We're not trying to get too in depth with these, but we want to cover some, many of the questions that I get. And so again, I'm Mark Wight. Idaho Estate Planning is my law firm, and maybe you can tell by the name we do estate planning. So thank you for joining us again. Love questions. We might delay answering the question until a different time, but if you have questions, type in the chat and let's get going. All righty. So now this has become common. What is an estate? That's a comment I get a lot. Talk about estate planning. And so many people say, I don't need to do any planning. I don't have an estate. And I think this is Downton Abbey that we have a photo of here. And so a lot of people are thinking, well, an estate is this large, either an estate like this big building with the grounds and, they go hunting foxes with your hounds and everything, or it's just a large amount of assets. And truth be told, in the legal field, an estate just happens to be anything that you may own at your death. Okay, that sounds really weird. You're thinking, no, it's got to be a lot of stuff. No. The probate estate, we'll talk about probate in just a minute. Probate estate is simply anything that you happen to own at your death, and can include, by the way, any amounts of money that you owe. That all goes into the definition of probate estate. So it's not just this big piece of property. In fact, it can be a number of things. Your car, whether it's an old car or a new car, whether you owe money on it or not, whether it runs or not as part of your estate. Records, I'm thinking more in terms not of vinyl, although if you do have lots of vinyl, let me know. That's really come back in vogue. But I'm talking about records that you are keeping of your business, your taxes, all that, part of your estate. Your house, any real property, if you've got a cabin or recreational property, that's part of your estate. Anything that you have online, this is a newer thing, especially for attorneys, is the, any social media accounts that you have. If you do your banking online, I participated in an hour-long presentation on Bitcoin. And if you're not familiar with Bitcoin, good luck. I was not that familiar with Bitcoin. It is something that doesn't really exist, but it's worth money. It's part of your estate. And Bitcoin, by the way, is truly an interesting thing to take care of after you die. So why do we care about planning those things that you might own at your death or even right now? Well, at your death, after your death, if you want to have a say in who's going to receive those assets, then you want to do some planning. If you want to minimize the cost of, transitioning those assets from your estate, say to your spouse or to your children or to other relatives or to people, that you want to direct it to, or an institution, if you're doing some charitable giving, then you want to do some estate planning. So yes, of course, that makes sense. At your death, estate planning, we're planning for that. We will make sure everything's taken care of. In addition, though, if you became incapacitated, so if cognitively you have some challenges and are not able to make good decisions concerning your assets or taking care of yourself, then if you plan, you can determine who makes those decisions, who controls your assets, who manages them for your benefit. Okay, so that's the planning on the incapacity side, is choosing who will make those decisions and then giving them instructions. That's included in estate planning. Who will make, yes, ma'am.
Quick question.
Sure.
Wondering if you recommend trusts for minor children.
If you'll hang on to that, we're going to get there.
Good deal.
Because if you want to talk about protecting assets for the benefit of minor children, trust happens to be a very good tool. So Hank, hold that thought. And then who's going to make medical decisions for you? If you want to direct who that is, then you do need to do some planning. We got to put it on paper and you got to sign it and all that good stuff. Now, in Idaho, your spouse can generally make those decisions for you if you're unable to for whatever reason. Then typically medical care providers will look to your spouse and will take the direction from the spouse. But let's say that you're not married, that you have a significant other or a same-sex couple that's not married. The medical care providers may not be as inclined, which has historically been the case, to take instructions from someone like that. So what do? You plan ahead and you write it down and you say, I want, whoever that is, to make those decisions for me. So those are the reasons to do estate planning. Plan for while I'm alive and then what happens at my death. So for us, your estate plan should cover when you're alive, when you're disabled, when you're deceased. Boom, boom, boom. And you know what, Michelle? This is a great presentation, but it's one we already did. I pulled up the wrong PowerPoint, folks. Can you hang on just a second while I undo this one?
Mark is human, guys, so bear with him. He'll grab the right one.
I love it.
You can all have a good chuckle with us.
Well, I know some of the people that are on and they are already chuckling at us, so you don't have to worry about that. All righty, so give me just a half a second because did I lose you?
We're here.
Okay. All right. Well, I've lost myself. I have no idea where I am anymore. So hang on just a second. That is really, really weird what my computer just did. I apologize profusely. I've lost my Zoom. So you can hear me but can't see me?
I can see you and hear you.
Oh, well, how come I can neither see myself nor hear myself?
That's a conversation for another day.
That is another day. All right, so hang on, just hang on a second. I will get this back up real quick because I just a second ago, I worked on this and I had that, and now I cannot find it. You know, I've had a lot of problems like this before, you know, in the past, but I thought I overcame them all. And, oh, I know what I did. Sorry, everybody. I apologize profusely. I will get us back on here in just a second. Oh, my goodness. I lost my mind. Absolutely lost my mind. And this is going to look good on the recording too. Thank you so much. All right, let me try this again. Oh my goodness. This is the one I want right there. Oh, let me see if I can pick this back up. Hang on. Now, am I still sharing, Michelle?
You should be. I haven't changed anything.
Okay. All right. So I guess if somebody will plug in and tell us if we're still sharing. Can you see my screen?
I cannot see your screen.
If I do this right here, and I do this right here.
Now you're there, but you're on the click to add a title. You're in the old mode where you have the one screen and then the next slide. This is what we rehearsed 20 minutes ago.
I'm loving this. All right. All right. Oh my goodness. Here
Now you're back in business and I'll go back to mute.
All right. Very good. Thank you. Oh, thank goodness. Oh my gosh. All right. You know, we're supposed to be quick on our feet and all that good stuff. I didn't feel like it. So you hear a lot about probate. What is a probate? Because for a lot of people, that kind of drives their concept of estate planning. And like I said just a minute ago, if you can remember back that far, before I lost you all together, probate, the probate estate, that's defined by state law. And that's that thing I said, when something you own, anything you own at your passing, including debts, anything that you might owe. So what is probate? A lot of people ask that question. They're not even sure what probate is. Well, probate is, in fact, a legal proceeding. So when somebody passes away, we file in court. It's not really a lawsuit. It could end up that way. In fact, I'm involved with 3 of those right now that ended up as basically a lawsuit. But we petition the court or file an application, and it begins this legal proceeding. And then the judge, we put in front of the judge the will, if there is one, and we're going to talk about that in just a second. We're going to put in front of the judge the will and ask him to enforce the provisions of the will. And so the will then becomes the instructions to the judge. I'll get into that just a little bit more in a minute. But the thing about probate is that was developed years and years and years and years ago, actually a millennium at least ago, when a person died. In order to transfer the title to property, whether it's your house or your car or an account, in order to transfer that to someone else, I need your signature. Well, when you're dead, it's really hard to get your signature. I have stories. People have suggested it has been done. But it is difficult to get someone, a decedent's signature on a deed. So the courts came up with this process where the court appoints someone to represent the deceased person's estate. And nowadays we call it a personal representative, if you've heard the term executor or executrix for a female executor. Those were the terms used for a long, long time. In the early 70s, we developed the Uniform Probate Code and came up with a gender-neutral term, which is personal representative. So the personal representative then has authority given to them by the judge, and now they can sign off on the deed, on the title of the car, on the account, and so that's the process. That's what probate does. It appoints somebody that can do that, can transfer the property, and then holds them accountable for doing that. Now, I put on this slide that it provides a forum for a will contest. Well, it can be. It can be a forum for a will contest. So what does that mean? Well, if somebody doesn't like how they're being treated in the will, then they might be inclined to bring an action to challenge the will or challenge the actions of the personal representative, or explain that the deceased person was under undue influence or yada, yada, yada. So those are some things. It can be time consuming and expensive. It typically isn't, but it can be. So then what is a will? Well, a will then is your instructions to the probate court, right? It's you telling the court how you want things done upon your death. So it becomes effective on your death. The will doesn't become effective before that. I think we've talked a little bit about that. I've had families come in and they want to do, say, estate planning for mom, and one of the kids, and I don't mean to be sexist, but it's often one of the boys says, well, I'm mom's personal representative. And I try to be kind and I ask, is mom dead? And they look at me like I've lost it. And they said, no, she's sitting right there. Well, then as a personal representative, there's nothing you can do. She's still alive. She's still in charge. At her passing, then come and see me, okay? And so the instructions to the probate court, it tells us who's going to be that personal representative. And then your instructions, you're going to mention how you want your property managed, who's going to pay the bills. And then the most important thing is how do you distribute that property after your death? So if the will is simply a set of instructions to the judge, so let me go back up for just a second. The instructions to the probate court or to the judge, shouldn't everybody have a will? Well, sure, they should have a will. It's a really, in a minute, we're going to talk about should they have a will or a trust, and then we're going to talk a little bit more about how should we have a trust for the minor children. So the will is a very good document to have in order to make sure that your estate is managed properly. However, a will make sure that you go to probate. Now, that's a question I get quite a bit. Well, I have a will. If I have a will, I don't have to go through probate. Well, if I have a will, I still have assets in my name. If they're in my name at my passing, then I'm going to have to go to the probate. I need the judge to authorize somebody who can sign off on my assets, whether it's the title of the house, title of the car, or whatever. So the will still take me through the probate. So hold that thought. Hold that thought. Well, then what is a trust? Well, a trust is a little bit different animal. So we talked about if you have assets in your name at your passing, we'll go through the probate process. That's how it works. What if, though, I took those assets out of my name while I was still alive? Well, you can do that. A trust is actually a relationship of a couple of people and property. So what do I mean by this? Well, let's say that I have a 1974 red Corvette. It is, it is one of my favorite things, but I'm going to leave the country for a period of time and I would like the kids to be able to use it. I just don't want them to own it. Okay, I don't want to just give it to them. So then the question becomes, how can I arrange that so they can use it without owning it? And how do I trust them to do the right thing? Well, my brother happens to be a mechanic. He loves cars. He knows how to take care of this car. So if I go to my brother Mike and I say, Mike, I'm giving you the title to my 1974 Corvette for the benefit of my kids. Okay, so Mike, I'm giving you the Corvette. It's not really yours. You're holding it for the benefit of my kids. I've created a trust. And actually you can create a verbal or an oral trust. Not the best way to do that, by the way, because what are your instructions? And how do we know that those are instructions? If we have questions about the instructions, wouldn't it be better to have that all written down? Well, that's what we typically do then, is we have a written trust agreement that specifies the property and what I want my trustee to do with it. So my brother Mike would be the trustee. The assets of the trust are the Corvette, and then the beneficiaries, my kids. Okay. If I wrote that up, I'd have it, in writing. So the written instructions for the trustee, this is what I want them to be able to do. I want them to be able to drive it 3 times a week, but not 4. I don't want them driving after dark. I don't want them drinking and driving. And so you put that all in there. So I can do a similar thing, though, by taking, say, my house and deeding it over to myself as the trustee. Now, okay, so just go with me for a second. I deed the house to myself as the common trustee of the Mark Wight Trust. Now, why would I do that? Well, if I specify in my instructions a successor trustee, rather than going over to the court to do a probate, I can, in my instructions, say, if something happens to me, if I become incapacitated, I'm disabled, then I want my brother to continue to be the trustee. He steps in, he's the trustee, didn't have to go to court to do that, didn't have to do the probate thing. It's a private situation. He becomes the successor trustee, and as the successor trustee, he just follows along in the instructions that I put together in my trust document. So, instructions to the trustee, he steps in, then he can manage those assets if I become disabled or if I'm incapacitated. He talks about how to manage it, and at my passing, the trust doesn't necessarily die. If I say I want it to be dissolved and all the assets distributed, it's done. But the question was, what about for minor children? Well, this is a perfect tool for managing assets for the minor children. I can say to my brother Mike, okay, for my minor children, I want you to manage the assets. I want you to, invest them appropriately, and then I want you to pay attention to what their needs, continuing needs are, and make distributions not to them necessarily, but for their benefit. So let's say the kids go live with grandma and grandpa. Mike's the trustee. Well, Mike's in contact with mom and dad, with grandma and grandpa, and said, what do you need? Oh, we could use a little bit of help because, you know, that middle kid is growing like a weed, and he's gone through 3 pairs of shoes, and he wants to go out for football. And, you know, the youngest one is into music, and we want to get music lessons. And of course, they want to play the tuba, which is an expensive instrument, and then we've got to transport it back and forth. So then the trustee is in a position to make the similar decisions to what I would have made. And so that's the power of the trust. So the will tells the court what to do and make those distributions. The trust is more of an ongoing thing and kind of replaces me. So I can make a deed of my house to myself. So then, as opposed to the probate, what's a trust settlement? Well, it's a private proceeding that's done in my office all the time. We get a call that says mom passed away. What do we need to do? We'll come in, and then we're going to visit and talk about the administration of the trust. We have some documentation that the successor trustee, you know, signs off on. And then we look at all those instructions. What are the instructions? What did mom want to have happen? And then we don't have to go through the probate process to do that. We talked about how the probate might be, could be a venue for a challenge of the will. Trusts are a little bit more difficult to challenge. It's not that you can't, it's that when you do the probate, you're already in court. We've got the magistrate, he or she's in charge, and if I don't like what's going on, then I file an objection. It shuts down that proceeding until I'm satisfied, or until the judge tells me, sorry, you're not gonna be satisfied. Here are the instructions. Typically, why does somebody object? Typically, not always, but typically because they're not getting what they think they should be getting. And so if you want to avoid court, then you try to make them happy. And how do you do that? You generally give them more than what the deceased person wanted them to have. And so if you want to avoid that, the trust makes it more difficult to challenge, because if you're a trust beneficiary and you don't like it, then you can challenge it. I said that before. So here's how you do it. You go hire an attorney, you pay them some money, and then they've got to get their hands on the trust, which may or may not happen depending on how this person is positioned in the trust. If they're not a beneficiary, they're not entitled to anything. Well, there's no ongoing proceeding, and so they have to hire an attorney, pay them some money, and bring an action. Most attorneys aren't going to do this because they don't have a copy of the trust document, so they don't know what they're getting into. And so it's more difficult, not because it's legally impossible, it's just because practically it's a little bit more, it's more difficult to do. So if you were to look at this from the initial cost and from the initial work that goes into it, a will is not as expensive and not as much work goes into it up front. But on the back end, there's more work involved. And then the probate process is, or can be, very expensive. Trust, on the other hand, there's more work, right? We're going to do all those instructions, and then we're going to talk about funding in a minute. And funding simply means we've got to retitle those assets, right? So instead of Mark Wight owning it, it's going to be Mark Wight, trustee of the Mark Wight Trust. So then we've got to change all that. So the work up front is more and the cost up front is more, but on the backside, it's much less. So you kind of got the teeter-totter going. Will's cheaper, more expensive at passing. Trust is more expensive, cheaper on passing. Now, if you added into that the someone becoming incapacitated, then it's a similar thing, and actually can be more pronounced. So if you don't have a trust and you don't have, say, a power of attorney, then great, that was cheap. That was really easy. But if you become incapacitated and we needed to manage assets, we talked about this last time, you could end up doing a conservatorship proceeding. Well, that's kind of expensive, and then it's got a continuing or ongoing expense to that. On the other hand, the trust, again, more expensive, more work, but then we don't have to go through the conservatorship process. The trustee steps in, manage the trust, not subject to the continuing jurisdiction of the court. And so that makes that much simpler and much easier going forward. So the question becomes, well, why don't I just use a power of attorney? Mark, why can't I just use a power of attorney and make sure everything works that way? Well, one of the things that we've run into historically is that a power of attorney can't do everything. And we've run into a number of situations where, whether it's a bank or an investment company or a mortgage company or whoever it might be, has come back and said, oh, by the way, your power of attorney is more than 6 months old, or more than 3 years old, or more than 5 years old. Go out and get a new power of attorney. Well, if you think about that for just a minute, you'll see that that's a struggle, right? If we're using the power of attorney because someone is incapacitated, we can't go get a new one at that point. We're kind of stuck with the old one. So what's our option? And we talked about this. You're going to end up with that conservatorship. So the power of attorney is not going to help us if we're in a situation where it's going to be ignored. And I will tell you that many banks don't like them if they become stale, is the word, that they're a little bit older. And part of that is because they don't know if the person who made the power of attorney didn't make a different power of attorney. Well, if this one's 5 years old and I saw one that came in, it was 41 years old. It's logical assumption that there's got to be a newer one out there. And if there's a newer one, who's that power of attorney supposed to be? So I can see a bank getting a little bit concerned about someone coming in and just saying, hey, I'm the power of attorney. And they have no other reference to what that is. Not too long ago, it's been a few years, the state legislature passed some legislation that said that you could request from the person presenting the power of attorney an opinion letter from an attorney. You can go to an independent attorney and you could get an opinion letter from the attorney, and the attorney would, in the opinion letter, say, yes, I've reviewed the situation, I've reviewed the power of attorney, it is valid, it is in full force, and no, I'm not aware of any other one. And that makes the banks feel a little bit better, but I've still had the situation where they said, no, go get the conservator appointed, and then we know the conservator is subject to the jurisdiction of the court, is accountable to the court, and then we know everything's going to be done right, and we as the bank aren't going to get sued later because we did something wrong. The other part about the power of attorney that's really difficult, though, is it's not valid after the principal passes away. So the will is good till, not until someone passes away. The power of attorney is good until someone passes away. So if you're keeping score, here's a little chart that I've used to kind of help us understand the different tools in when do they become effective, or maybe, you know, give us an idea on how to understand perhaps what's best for our situation. So I have to stop here for just a second and talk about what if you don't have a will? And this is going to sound a little bit crazy, but even if you don't do a will, you don't create one, and you don't sign it and do all the things you're supposed to create a will, there is one in place for you. In the Idaho Code, Article 15, if you care, Section 2, there is a provision in there, and it's called the intestate provision of the Idaho Code. Intestate is just simply the lawyer's horrible wrenching of Latin, and what it means is you're not alive, or it means you don't have a will when you die. So intestate means you have no will. So in 1974, the Idaho State Legislature was, you know, trying to figure out, well, what happens if people come in and they don't have a will? And that's a problem that goes back much before that. But in 1974, the Uniform Probate Code, we adopted that here, and that gives us some basic instructions of what might happen, or what will happen if you don't have a will. So it follows some logic. I think you can appreciate that. So for example, husband and wife, it's their only marriage. They acquire assets together. So those are community assets or community property. Husband dies, everything goes to his surviving spouse. What if they have kids? Everything still goes to the surviving spouse. What if one or both of them were married before this marriage? So let's say this is his second marriage. He has children from a previous marriage. At his death, what happens to the property? Well, community property goes to the present spouse. Nothing goes to the ex-spouse, and nothing goes to his children, either children from a previous spouse or children from the present spouse. What if he has separate property that he had before they got married? Well, the separate property actually gets split between the present spouse and his children. And if it's just children from a previous spouse, then it's split 50-50. If there are children from a previous spouse and from the present spouse, then the children together get 50% and the present spouse gets 50%. So what does that mean? Well, that means that you can absolutely accidentally cut your children out of an inheritance. And maybe that's what you want. But if you don't write a will and you use the intestate provisions, and you have all community property at your death goes to your present spouse, and at her death goes to her children. Now, those might be your children as well, but children from a previous spouse are now cut out. Perhaps they're her children from a previous spouse and you never liked them. They never liked you. Well, they're now inheriting at her death. So if you don't want those intestate provisions to go into effect, you've got to have a will. And so, does a will avoid a conservatorship proceeding? And we talked about that. Well, no, because that's not what it's for. Will you have a probate if you have no will? Absolutely. It puts us in the same position as if you have a will. You have a written will over here, you have an unwritten will over here. We're still going through the probate because those assets are still in your name. We have to appoint a personal representative who can then make those distributions. So if you're married and you don't have a will, do you avoid probate on the second death? Oh, no, you don't do it on the first and you do it on the second one. If you have no will, have you controlled the distributions of assets on the first death? No. You have, by default, you have this unwritten will, and the judge will just look at that and will absolutely follow the provisions of the Idaho Code. You didn't do anything different than that. Same thing on the second death. No. Do you get any sort of estate tax savings? The answer is no. And that's really not an issue right now. If your estate is, the value of your estate is less than $11,580,000, there's no estate tax, there's no death tax, there's no inheritance tax, there's no transfer tax. So you don't have to worry about that right now. In a few years, we could be right back to the limit that we had a few years ago, which was 2.5 or 3.5 million. And the cost of the COVID thing that's happening to our economy, and then what the government's trying to pump into the economy, you could easily see them reverting back to those lower limits. But right now, it's 11,580,000. And if you have more than that, you should see me, because we could, could hang out, we could do some things. So what if your estate plan was simply giving away all of your assets? Does that avoid conservatorship? Well, you'd think if you gave it all away, you wouldn't have to do a conservatorship. You don't need a conservator, you don't have anything. It's actually not true, though, because you still need to pay bills. Got to figure out how to pay for maybe long-term care. So you may still need a conservator. Can you avoid probate? Well, if you don't have anything to give away, then we've certainly avoided probate. What about on the death of the second spouse? Well, it depends. What did we have? Do you control the distribution on the first death? Well, yes, I suppose, because you gave it all away already. Then we don't have anything to give away in the probate. Do you control on the second death? Well, there's not much there. Any estate tax? Not if we gave it all away. What if we own something as joint tenants with right of survivorship? So right of survivorship simply means whoever lives longer takes. So if I own real property, my house, as a joint tenant with my wife, and I put that on the title joint tenancy with right of survivorship, then at my death, she inherits the whole thing. If it's my brother, we own a mining claim together as joint tenants with right of survivorship. Then at my death, he owns it. Actually, do you need to do a probate with joint tenancy, right of survivorship? Nope, you don't really have to do that. So that's fairly easy, but you better understand that's what you've got. Do you avoid probate? Maybe, maybe not on the second one, because if I die, my wife has it, owns it, and if she dies, there's no joint tenancy left. Did she, give that to somebody else? Does she have a will? Does she not have a will? We're going to go through probate on that. We didn't talk about this, so I'm sorry, I'm just jumping sideways a little bit. Beneficiary designations. These are like a payable on death beneficiary, or say beneficiary designation on life insurance or a retirement account. Doesn't avoid a conservatorship. We're not too worried about that tonight. Does it avoid the probate? Yes, it does, because by the contract, by the operation of law and the contract, it goes to whoever I put down as my beneficiary designation. Does it avoid probate on the second death? Well, if I've made my wife the beneficiary and she doesn't make somebody a beneficiary, then I'm going to be doing that probate again. And you can follow that through. Power of attorney is it's not supposed to avoid probate or anything like that. It's really for incapacity. Now, simple will. Does the simple will avoid conservatorship? Well, no, it doesn't. That's not its job. But will the living trust avoid probate or conservatorship? Yes, it absolutely can. Does it avoid probate? Well, the simple will does not. It'll take us into probate. The living trust, if it's done correctly, no probate. What about on the second death? If I leave everything to my wife, will she have to go through probate, or will the kids go through probate at her passing? Absolutely. What if it's a living trust? Nope, if we've done it right. Can I control the distribution upon the first death with a will? Yes, that's the whole idea. And a living trust? Yes. Still does it. What about the second death? Again, if my will leaves everything to my wife and she doesn't have a will, my will doesn't control those distributions. But the trust can do that. It can control the distributions after the death of both spouses. And by the way, with a living trust, I can actually double the amount that you can pass free of estate tax. That's a nice thing. So again, if you have more than 11,580,000, give me a call. Yeah, we can hang out. That'd be great. But there are some planning tips that we can then work you through and make sure that we're saving taxes. Now, how do you create a trust? Well, again, the attorneys really like to use Latin. They don't use it well, but inter vivos means during life. We create a trust during your lifetime. And so we create it, say, well, I want a trust, and here's who's going to be the trustee, and here are the instructions. Testamentary trust, if you've heard that term, just simply means created at death. Okay, so the way I would create that is I would create a will, and in the will I would have provisions that set up a trust for the benefit of, say, my kids or my grandkids. So I would go through the probate. So the thing about a testamentary trust is I don't avoid probate if that's a concern. I will go through the probate, I will create a trust there, and then my assets will flow through the probate into this testamentary trust. It can be a great tool, especially younger parents, maybe don't have a lot, but have a life insurance policy, and they want those proceeds to go into a trust for the benefit of the kids. Perfect. We would create a testamentary trust. Why? It's cheaper. It's easier to set up. Yes, there'll be more on the back end, but we then have some insurance proceeds to help pay for this. And then maybe as they get a little older, we switch that and create an inter vivos trust instead of a testamentary trust. And I talked just a little bit about a revocable trust. A revocable trust means that you've hung on to all this power or authority to make changes to the trust. So you can tweak it, you can put assets in it, you can pull all the assets out of it, you can change that trust from time to time, which just logically you're going to, because life changes. You change, your family situation change, financially things change, your health changes, and all of those things will dictate that you're going to make some changes to your planning anyway. But a revocable trust allows you to make all those changes. Irrevocable trust means that you didn't hang on to all of that authority, all of those rights regarding the trust. You said, no, I'm done. Now, Does that mean you can never change an irrevocable trust? Well, because attorneys are attorneys, the answer is no, but it's hard to make those changes. And so I was on the phone this afternoon, actually a Zoom call with some clients that have an irrevocable trust, and we discussed the possibility of making some changes. Not easily done, and not because they can't make those changes themselves, but there's a process that we can actually make some of those changes. So revocable, can change it at any time. Irrevocable, not so easy to do. All right, so I think we're about out of time, and I'm about out of slides. Funding, what do we mean by funding? It means we're gonna fill the bucket. If you look at a trust like a bucket, we're gonna move some assets into the bucket. That is, we're gonna change the ownership. And so that will show the trustee as the owner. So if it's the house, instead of Mary Smith as the owner of the house, it'll be Mary Smith, trustee of the Blackacre Trust, or the Mary Smith Family Revocable Trust, or her successor trustees. If it's a bank account, then again, it's not Mary Smith individually, it's Mary Smith, comma, trustee of her trust, whatever the name is. What if we have a life insurance policy? Do we change the ownership of the policy? Well, it really depends, but we don't have to. We just want to direct the proceeds to go to a particular place. And so instead of having the kids, maybe minor children, as the beneficiaries of that life insurance policy, we make the trust, Mary's trust, as the beneficiary of the policy. So at her passing, the life insurance pays out, those are proceeds, and we have those right into the bucket where we have the instructions for the successor trustee to take care of the kids or take care of them financially. So I've had people that have put together, whether it's a testamentary trust or an inter vivos trust, and then they didn't go through and change the life insurance. They didn't change the beneficiaries. So we did all this work to put that together. They didn't change the beneficiaries. And I'm telling you right now, the life insurance companies will not write a check to a minor. They're not going to do it. Instead, they're going to require that you go do a conservatorship for the benefit of those kids. Well, if you're doing a trust, we should make sure everything's put into the bucket appropriately so that we don't have to then turn around and do a conservatorship for the benefit of the kids. So if you ever hear the term funded or unfunded trust, what we're talking about is, did we retitle, re-register the assets into the bucket so that the trustee has authority over that? Quickly, what goes into the bucket? We talked about real estate, the residence, the cabin, or any other recreational property. If you have a timeshare in Mexico, that one's going to be a little more difficult. We've done timeshares, but Mexico can be really interesting. Accounts, checking accounts, savings accounts, money market accounts, investment accounts. Stock can be retitled over to the trust. Can the trust own a business? Yes, it can. If it's, say, a corporation, we just move the trust maker's shares of stock into the trust. Who owns the corporation at that point? The trust. Who manages the trust? Well, the trustee. Who's the trustee? Well, if it's Mark's trust and Mark's alive, typically he's the trustee. And then he manages everything, in the trust, including the shares of stock. At his passing, then, do we go through the probate to retitle the stock into, say, the kid's name? No, don't have to. It's in the trust. And if we have minor children, we leave it in the trust and we take care of it that way. Personal property, we can I tend to not with, say, cars or a truck or some of those toys. And the reason being is because it's still fairly easy at the Division of Motor Vehicles to transfer that, even when somebody's passed away. If that changes, there's work that I'm going to have to do. What if somebody owes you money? You've got a note. Can that go into the bucket? Absolutely. And by the way, it should go into the bucket. Talked about that just a little bit earlier. I just wanted to review that here. Trust settlement is a private proceeding. We just enforce the trust's instructions. It's the mechanism for determining if there's any money owed and how to manage the assets if somebody becomes disabled. And then at the passing of the trust maker, what do we need to do? Like I said, it's difficult to contest, not impossible, but generally very difficult. And the trust settlement is really quite inexpensive considering that we've done all the work before. So all that work we did to put assets into the trust or retitle, that's what you do in a probate after somebody passes, except they're not here to sign off on all that. So that's why we have the personal representative. They turn around and they do all that. So we talked about the incapacity planning already. We talked about how expensive and time consuming that the process is. Michelle, I see that we got about 3 minutes. I don't know if we've had any questions. I know I've done such a sterling job that people don't have any questions.
There have not been any questions. If you have them, please type them into the chat box and we can get them over to Mark.
Yes,
and you're
absolutely.
right, we have 2 minutes. You're right.
Got a couple of minutes. So couple of things then to leave you with. If you got questions, give them to me. We'll handle those. In the meantime, well, I'm going to go ahead one and then come back to this. I wrote a book. It's called Get Real, Planning for Life, Death, and Disability. It's about 5 steps to get organized, take care of yourself and your family. And here are the 5 steps. Get real is to realize we're not going to live forever on this planet. We're going to die at some point. So we got to think through that. I know that's hard to do. It's just hard to contemplate our mortality. I get that. Second was get motivated. For me, it's about family. For me, it's about the commitments I made to my sweetheart and to my children and my grandchildren. And that's what motivates me. And we find with most clients, that's what motivates them. And then get it together. I have some instructions on there how to pull information together. Step 4 is get the help. Attorneys are the folks that put together wills and trusts to do that planning. That's a good place to go for some help with putting the plan together, but there are financial advisors that can help out. There's other advisors. We had one couple that came in and one of their advisors was their clergy, and that was perfect. And then step 5 is to get it done. If you go to the website and say there's a place on there you can click and order up the book, let us know that you heard me on this. We'll send you one. We'll send you a free book, and hopefully it'll get you going in the right direction. Did we get a question in?
We have no questions.
Oh, well, somebody said show your book info again. Oops, too far. Hang on. Back up, right there. I didn't lose it this time. I did last time, I gotta tell you. I kind of lost it. No idea what I was doing. Oh. Any other questions?
Well, if there's nothing else, I want to thank everybody for attending tonight. I want to thank Mark for a wonderful presentation. I know I learned a lot, as I always do. Chat will be live for another moment, maybe another 60 seconds or so if you have a question. Otherwise, you're free to take off. Thank you very much.
Thank you, everybody. Take care and stay safe.